Good evening, everyone, and welcome to tonight's session of our Living Well with ALS webinar series, proudly presented by ALS United Greater Chicago. We are so grateful you have joined us and appreciate your time and participation. For those joining us for the first time, our quarterly webinars are designed to provide practical guidance and valuable insights for individuals and families affected by ALS. Tonight's webinar is titled Legal Planning for Individuals Living with a Chronic Medical Condition, will be led by our guest speaker, Courtney Veneri, Associate Attorney at Dutton Casey Mesoloras. Courtney specializes in elder law and life care planning and will share essential legal tools and strategies to help individuals and families prepare for the challenges that may come with ALS and other chronic medical conditions. She will cover powers of attorneys, trusts and wills, legal options for planning and paying for long-term care, and she will briefly touch on how Medicare, Medicaid, and long-term care insurance can help support quality of life. We will have time for questions at the end, so please add yours to the Q&A section as we go. If you have additional questions afterwards, feel free to reach out and we will do our best to assist. Before we get started, I would like to go over a couple of housekeeping notes. All participants are muted to ensure smooth experience without background noise. Tonight's session is being recorded. Registered participants will receive an email notification when the recording is available. Thank you again for joining us. Now let's get started. Courtney, thank you again for being here with us today. The virtual floor is all yours.
Thank you. And thank you everyone for coming today. It's been kind of some nasty weather, so probably a good day for a webinar, though the sun's coming out a bit. I'm going to share my screen. So if we can get started. Okay. So my name is Courtney Veneri. I'm an attorney with Dutton Casey Mesoloras, and I do specialize in elder law and also long-term care planning. So today we're going to be talking about legal planning for living with a chronic medical condition. Okay, just kind of a brief overview of what we're going to talk about today. We're going to talk about healthcare decision-making, financial decision-making and management. These are, kind of times when we'll talk about wills, trusts, care planning, and then long-term care costs and kind of go into each of these. So, oops, sorry, I think I missed one. Okay. So we're going to start with kind of this quick overview of surrogate decision-making. So this is essentially, this question is, who has the authority to make healthcare and financial decisions? So to start with, number one would be the patient, if not incapacitated. So there's a legal presumption of capacity, which means that we presume that the patient, if they're able, if they're awake and talking, we presume that they're able to make healthcare and financial decisions for themselves. However, that's not always the case. Some people may not be awake or able to speak and communicate their needs. And then, sometimes for conditions like dementia, they may have capacity at one point and then not have capacity later. So after the patient, right, there would be the agent of or under power of attorney. And we'll talk about that in more detail, but this would be the person appointed by the patient when they had capacity. And they say, yes, this is the person that I want to make decisions for me. If there is no power of attorney in place, then we would look at a surrogate under the Illinois Healthcare Surrogate Act, or potentially there might be a court-appointed guardian if somebody does not have a surrogate who's willing or able to step up and make these decisions. So powers of attorney, we're going to talk about kind of these two main powers of attorney. There's one for healthcare, so that allows another person to make medical decisions specifically for the principal. And then there's the healthcare or the power of attorney for property. which allows the agent to manage and access the principal's property, which includes real property, so a house, a condo, and personal property, bank accounts, clothes, a car. And so in this case, the principal is the individual appointing someone. So, a patient putting together a healthcare power of attorney would be the principal. The person they appoint is the agent. So the agent under a power of attorney is legally authorized to act on behalf of the principal who appointed them. And this requires legal capacity to execute. So essentially, the question that we're asking is, does the individual have the ability to understand the nature and effect of the document that they're signing and of the transaction? Kind of, a way to think about this, right, is someone who is diagnosed with dementia and they're in the very early stages. They may do a power of attorney and they have the legal capacity to execute it. They know what document they're signing, they know why they're signing it, they know who they're appointing, why they're appointing them. But as something like that progresses, they may not understand anymore what it means to sign a power of attorney. And at that point, they would not have the legal capacity to execute that document. So this is kind of looking into, do you understand the significance of what you're signing? So for healthcare decision making specifically, a power of attorney for healthcare, you are only able to name one person to act at a time under the statutory form. You can have successor agents. So if you nominate someone for healthcare, you could also put in your power of attorney, if this person is not able to or not willing to act, I then would nominate this other person. Um, so this allows them to designate another person, the agent, to act for them as described in the power of attorney document to make healthcare decisions. They stand in the shoes of the principal and they're legally authorized to act. This includes that they could act to withhold or withdraw life support, as well as any other healthcare decision making, including perhaps placement in a nursing home or other, facility if needed. So a power of attorney is it can be revoked by the principal, even if they don't have capacity anymore. So this kind of differs from the creation of a power of attorney. You have to have the legal capacity to sign a power of attorney for healthcare. But even if you don't have that legal capacity, if the principal wants to revoke a power of attorney, they still can, even without that legal capacity. You can amend a power of attorney for healthcare. For this, you do have to have legal capacity because that is, in effect, creating a new legal document. When you sign a new power of attorney, it revokes the old power of attorney for healthcare. And I do want to make the point that the power of attorney for healthcare and the power of attorney for property are different. You may designate the same person as your power of attorney for both. Many people do, but they are distinct documents. And a power of attorney for healthcare can be effective immediately or it can spring into action. So there's a statutory form in Illinois that will provide options for an effective date. Some people may say, I want this power of attorney to be effective immediately. In other cases, it may be a physician certifies, so it could be a written certification by a physician stating that the principal now lacks capacity to make healthcare decisions. So if you want to sign a power of attorney, but you don't want that person to be able to act until you no longer have capacity, that's an option that you could say it's not effective until a physician signs a certification saying that I no longer have capacity. And then a power of attorney for healthcare can be customized to the value of the principal. So if you're doing a power of attorney for yourself for healthcare, this is customizable based on sort of what you want. If there's types of medical treatment that you do or do not want, you can specify that in the power of attorney for healthcare. Life-sustaining treatment, you can specify that you do or do not want to be put on a ventilator, do or do not want to be given supplemental, nutrition. Um, this is kind of along with things like, do you want CPR? If you were to have a heart attack, do you not? And you can also add things like consultation with children. If you have one of your kids as power of attorney, maybe you put in there that they need to consult with the other siblings before removing life-sustaining treatments. These are things that are definitely customizable to the person. And with the power of attorney for healthcare, the agent can use substituted judgment in making decisions if you know of them. Otherwise, you have to act in the best interest of the principal. So if you appoint someone as power of attorney and you've talked to them about your wishes, but they're not outlined in the document, I definitely don't recommend that. I do recommend everything be in the document. But if it's not and they know of these wishes of yours, they can make decisions sort of based on what they know of your wishes. If they don't know any of your wishes, they just are required to act in your best interest. The agent for power of attorney has no duty to act. You can say that you can be appointed as a power of attorney and say you don't want to be that person's power of attorney. But if you do act, it has to be with due care for the principal. So you need to act in their best interests. You need to take into account, right, the things that are in the power of attorney for healthcare. You need to, as much as possible, do things within their interest that you know of. So that is power of attorney for healthcare. We're going to move on now to the Healthcare Surrogate Act. So this Illinois Healthcare Surrogate Act defines the circumstances under which private decisions by patients with decisional capacity or a surrogate decision maker can make medical treatment decisions or terminate life-sustaining treatment without judicial involvement of any kind. So this essentially is for a case where a principal or a patient no longer has this decisional capacity and they haven't signed a power of attorney for healthcare. So the Healthcare Surrogate Act defines under what circumstances could someone else act as a surrogate and make, routine medical decisions or even, discontinue life support. So the hierarchy of decision makers through the Healthcare Surrogate Act would be, first of all, the patient's guardian of the person. So if somebody has lost capacity, they can no longer take care of themselves, they may have a court-appointed guardian. And if there has been a court-appointed guardian of the person, which is different than the guardian of the state who would have kind of control over those financial matters. There's a court-appointed guardian of the person, that would be first. It would then go to the patient's spouse, any adult child of the patient, either parent, any adult sibling, any adult grandchild of the patient, a close friend of the patient, and then kind of last would be if there's a court-appointed guardian of the estate. So the guardian of the estate is someone who's kind of taking care of the bank accounts, the financial aspects of someone's life. So the Healthcare Surrogate Act would come into play if somebody did not have a power of attorney, they can't make decisions for themselves, and they need someone to sort of step into that role. Okay, so we're going to move on now to some financial decision making and management. Okay, so this kind of starts off, right, with this power of attorney for property. Like I said before, that is distinct from a power of attorney for healthcare. You could have one, you could have the other, you could have both. So it requires contractual capacity to execute This is kind of the same legal capacity for power of attorney for healthcare. You want to make sure that the person who's executing, signing this power of attorney understands what they're doing, that they understand what they're signing, why they're signing, who they're giving power to, etc. And it also requires that same capacity to revoke. So this differs from the power of attorney for healthcare, which can be revoked even without that capacity. But a power of attorney for property cannot be revoked without contractual capacity. And once a principal, so the person who signs the power of attorney for property, becomes incapacitated, neither them nor the agent can change the power of attorney or execute a new one. So this is in effect what makes the power of attorney durable. So this means it continues to be a valid document even after the principal loses capacity. And that is, definitely the point of the document, right? You're signing something while you have the capacity to decide what you want, the rest of your life to look like, while you have the capacity to do so, so that when you don't, this document continues on and the agent takes care of your wishes. Um, the powers of the agent defined in the statute for power of attorney for property are very broad. The document themselves, they can be modified and customized. And, many people will use kind of these statutory forms. You can customize that as well. But generally, the power of attorney for property does not include gifting power unless it's specifically included. So gifting power is, basically the ability of the agent to gift your property to someone else. Gifting, you know, can they give each of your kids $1,000 for Christmas? Probably not, right? Um, unless you specifically include in the document that you want them to have that power. You can specify that you only want them to be able to gift, I gift my kids $500 on Christmas. The agent has this power. You can customize it in that way. But one thing sort of to think about as far as power of attorney for property and gifting is if you are planning to apply for Medicaid and you have a house and you also have a spouse who may live in that house when you go to a nursing home, if the power of attorney is not able to gift, you could not give your interest in the house to the spouse after you lose capacity. And we'll talk about this a little bit later with Medicaid, but that can sort of affect your eligibility for Medicaid. So when it comes down to doing a power of attorney for property, I definitely would advise you to talk to an attorney if you're planning to do Medicaid, especially so that they can kind of help you understand the implications of either being able to gift or not being able to gift. Okay, so for power of attorney for property, this is kind of the same thing with the power of attorney for healthcare, where it can become effective upon the date of signing, but it can also become effective later upon written certification by a physician that the principal is incapacitated. So maybe you want somebody to be able to take control of your bank accounts once you're incapacitated, but maybe you don't want them to do it right now. You can have this power of attorney spring into action later once someone has signed off on the fact that you're incapacitated. And if the document was executed during a period when the principal lacked capacity, they are subject to challenge. And this is the same for property and for a power of attorney for healthcare. So this can be challenged in court, and a power of attorney can be invalidated by a court order. If somebody is, say an agent is kind of spending the principal's money very frivolously in a way that's not in their best interests, for a power of attorney for healthcare, if they're not taking care of that person or, making sure that they're in a setting where they are getting the care they need, that can be challenged through the court. That could be challenged by a family member, by an adult protective services agency, and there could be a court order that sort of removes that power of attorney in cases of abuse or neglect. So with the power of attorney for property, because you're dealing with somebody's assets, the agent must keep record of receipts. So any money they give, they need to keep a record of, receipts, any money they get, a record of disbursements, which is any money they give, and any other significant actions. So, really the agent should be keeping very good records of everything that they're spending, everything that they're getting, and what it was spent on, because there is a duty to account. So the agent must provide, upon request, a copy of the receipts, disbursements, any significant actions to principal or fiduciary on behalf of them. So Adult Protective Services Agency can ask for this, an ombudsman can, a public guardian, the court can ask for it. So, if asked, you need to be able to show everything that you've done. If you got Social Security payments and put them into this bank account, you need to account for that. If you're spending money out of the principal's bank account to pay for a nursing home, you need to be able to account for that. Significant actions, this, may come where if somebody has a brokerage account, some stocks, if you're making decisions about where and how to invest those stocks, that changes the value of it a lot. You would need to then be able to account for that if asked. So definitely something to probably be doing over time rather than waiting for someone to ask you for it, and then having to potentially account for years worth of receipts, disbursements, and other things. The agent can delegate authority to others. So, kind of in my example of having a stock account, the agent could delegate stockbrokers to manage those accounts in their stead rather than trading and doing stocks on their own. And the agent for a power of attorney for property is entitled to reasonable compensation. So, the agent would need to be able to account for what they were doing, the time they spent doing it, but they could be compensated for the time they spend managing the accounts and finances of the principal, and accounting for all of those things. So joint tenancy is kind of another consideration when you're looking at financial decision making in the long term. So joint tenancy is a form of joint ownership over a property where, or I guess a car, right? Any type of property where each owner owns 100% of the property together. So at the death of one of the joint owners, the surviving owners own the entire property together. There are absolutely advantages to a joint tenancy. There's no cost to set it up. It avoids probate for that specific asset. And it arranges the estate so that others can manage it during someone's incapacity. So if you have joint ownership over a house and one of the owners is incapacitated in a nursing home and can't make decisions, that other owner, because they own jointly 100% of the property, can do kind of basic things, get insurance on it, make repairs, and not need the principal or a power of attorney over that particular piece of property. But there are some disadvantages for sure to joint tenancy. So it is risky, right? A joint tenancy has ownership interest in the property. And so the property is available to creditors of the joint tenant. It could be potentially the subject of marital disputes, disabilities, other problems of joint tenants. And it doesn't allow for contingent beneficiaries if one joint tenant predeceases the other. So you can't say, if I die, my interest in this jointly held property goes to my daughter, right? Because if there's another living joint tenant, that interest will automatically go to them. The surviving joint tenant is entitled to the entire property at the death of another joint tenant. So if there are several people who are beneficiaries of someone's estate, you can't really name them all as joint tenants. It's riskier to do so. And so it can kind of cause problems in that way. And like I sort of touched on earlier, a Medicaid applicant is presumed to be 100% owner of all personal joint property. So Medicaid, when they're looking at your finances to see if you qualify, those pieces of property that you're a joint owner of, they would consider 100% of that value, even though you may be a joint owner with another person. So trusts are kind of another option that people may take to deal with their financial decision making long term. So a trust is a legal arrangement, and it's where one person or an institution holds the legal title to property for another person. So this will name a trustee who would administer the trust, and there will be rules and instructions within the trust for how that trustee operates, where money goes, when it goes there, that situation. So there's a revocable and irrevocable trust. We will start with trusts that can be revoked. So that gives the donor, the person that putting money into the trust, complete control over it. You can take back the funds, you can change the terms of the trust. That it gives the person who's putting the money into the trust full control. This is used for, there are some benefits to it for sure. Asset management is one. The trustee can administer and invest the trust property for the benefit of one or more beneficiaries. So the donor can appoint someone as a trustee and have them sort of deal with that trust property to make it grow and manage it in a way that will benefit the beneficiaries. It helps to avoid probate. So instead of going through the court when somebody passes away, the person who created the trust property would pass to whoever is named in the trust. Now, that requires that property was titled to the trust before death, but those things that were titled to the trust and put into the trust would avoid probate. However, that property would still be included in the donor's estate for tax purposes. So when you get to trust taxes, that property would still be considered. Helps for tax planning. So it can be drafted where assets would not be included in the estates of the beneficiaries, so avoiding taxes when they die. This is separate from being within the donor's estate for tax purposes, but can help, trust beneficiaries avoid that. And then also disability planning. Wills only provide for death. Trusts can help a person have a plan in place in the event of their own illness. So, for example, in a trust, you may put that the proceeds or like the profits or the money in this trust is to be used for me in the event that I am ill and need to be put into a nursing home. You can specify it should be used for you to have, a specific quality of life, and direct the trustee to use the money for your benefit in the way that you want them to. So that's kind of the nice thing about a trust as opposed to a will. So individuals who have been adjudicated incompetent, so essentially someone who's been adjudicated to not have legal capacity by a court, may still have testamentary capacity to execute, amend, or revoke. So testamentary capacity is they may have enough capacity to revoke a trust, to understand that they want to change something in the trust. Maybe they don't like their care somewhere, they want to change what they put in that. They may still be able to make changes to the trust, even if they have been judged incompetent by a court. And this can be established by a principal's agent under a power of attorney for property. if that specific power is granted in the document. So you may ask your power of attorney to set up a trust for your personal property at the point when you become incapacitated. Maybe you are in a nursing home, you won't be able to move back home, and you want your power of attorney to be able to put your assets into a trust for your benefit or for the benefit of your family. So when an individual under a guardianship, so someone who's been adjudicated incompetent by a court and given a guardian, when they lack testamentary capacity, the court may authorize the guardian to engage in estate planning on behalf of the individual. So making financial decisions to maximize the value of their estate and make sure they have the best care possible. So under a trust, there's duties of the trustee, of course, to prudently invest and administer the trust assets. They have loyalty to the trust beneficiaries, so no self-dealing. You do not want to, as a trustee, be making decisions for your own financial benefit. And they have a duty to account to trust beneficiaries and comply with the terms of the trust. So similar to the power of attorney for property, if you're a trustee of someone's trust, you want to make sure you're keeping really good records of what you're doing. Some disadvantages of a trust that can be revoked. Trusts are more expensive to create. They're going to include legal fees. With powers of attorney, there are a lot of, statutory forms that you can kind of fill out on your own, whereas a trust is a little bit more complicated and would be more expensive in that way. Assets have to be transferred to the trust, which is time consuming and an effort. If you want your house to be trust property, you're going to have to put your house title in the name of the trust, which can take time and be difficult. And so because assets are held in trust, it requires lifetime administration. You have a trustee who is going to have to continue sort of dealing with these assets, investing them, administering them throughout your life until sort of those final disbursements are made. And then the trustee has authority over trust assets and is limited by the terms of the trust document. So if you put together a trust, you put the terms in it, and you want the trustee to do something different with the assets than are written in the document, you would have to go and amend that trust to be able to do that. Now, there are irrevocable trusts, so these cannot be changed or amended by the donor. So any property that you put into an irrevocable trust can only be distributed by the trustee as provided for in the document itself. So, the last trust, you could make changes, you can amend. With this, cannot be changed at all by the donor. So the donor can set up a trust perhaps where they would receive income earned on the trust property, but the trust bars access to its principal. So you could set up where the donor gets benefits of trust profits or income, but you still would not be able to change the actual terms of the trust that you put that principal amount of money into. So a testamentary trust. So this is a trust that's created by a will. So there's no effect, that there's no trust in existence, no trustee to do anything until the donor's will goes through probate. It does not avoid the need for probate, right? It's because the trust would not be created until after probate is finished. And that trust would become a public document since it's part of the will. It can be useful in accomplishing other estate planning goals. So, for example, it could be used to provide funds for a surviving spouse who would be protected if they required a Medicaid covered facility. So, if you had a revocable trust, those assets would not be exempt from Medicaid requirements. And so that can affect your Medicaid eligibility in a way that a testamentary trust would not. And then also we have special needs trusts. So these are often called OBRA trusts, which you may have heard, but they can be used to assist a person who is or may become eligible for SSI, Social Security, or Medicaid. It can be established by the individual themselves, a parent, grandparent, guardian, or Court order. And most special needs trusts are irrevocable. And these trusts don't affect your Medicaid eligibility. So there are two types. These are for people who are under 65 and disabled, or they're for people who are over 65 years old. There are two types of these special needs trusts that you could put together, or someone can put together on your behalf if you end up needing it. For example, maybe you're under 65 years old and become disabled and can't establish a special needs trust yourself. Someone else can do that for you. All right, we're going to talk now some about care planning. We'll first talk about the practitioner's order for life-sustaining treatment, this POLST. So in Illinois, the POLST form, it's a revised version of the DNR that people have heard of a lot of times. And this is an order that reflects that person's wishes, and it travels with the person across all settings of care, and it has to be honored by all healthcare providers. It's intended for a person who's seriously ill or with a life-limiting illness, and it's completed after a patient discusses their preferences with healthcare professionals. It's signed by the patient or patient representative and the qualified healthcare practitioner. So a physician, licensed resident, etc. And this allows you to sort of put together your wishes. You'll talk through it with a healthcare professional. They can help you understand what decisions you're making and the impact of those decisions. And then you would sign it, they would sign it, and you would keep it with you at all times. So that if you are moved from a hospital to a care facility, you have these wishes listed out for you, and that other facility that you move to has to honor them in the same way. So this is an option for you to sort of put down your healthcare wishes and healthcare decisions, to talk about them with someone who can help you make informed decisions about your care. And then it's something that has to be honored by any healthcare provider that you're working with. Another sort of similar care planning thing that people use is called 5 wishes. So this is an advanced directive form that's legal in 42 states, and it's available in 29 languages. Illinois is one of those states that that it's legal in. This is written in everyday language and includes instructions. So as opposed to this this previous POLST, that form is a little government form, right? It's not the easiest to understand. It's not the easiest to fill out. There are things that may confuse people, whereas 5 wishes is intended to be easier for just kind of anyone to understand and anyone to fill out. It includes all the instructions and information you need to create a valid advance directive. One of the nice things about the 5 wishes is it covers personal, spiritual, medical, and legal wishes all in one document. So if there are kind of specific, maybe religious things that you want to specify as far as what medical care you do or don't receive, this is something that would cover that as well. And it allows your family or caregiver to know exactly what you want. So what's nice about it being legally valid in most states is that, since it's not an Illinois specific form, it's something that your family could have and you could have if you were receiving treatment out of state. So definitely something that even if you don't fill it out for use as a legal document, I think it is something that's helpful for people to kind of think about what they're wanting in these different areas, right? Personal, spiritual, medical, and legal, and start making decisions based on that. All right, and then we'll talk about long-term care costs. So long-term care, it's essentially medical and non-medical care given to people who are unable to perform basic activities of daily living. So toileting, bathing, transferring in and out of bed, feeding yourself. Long-term care may be provided at home. It can be provided in the community or in long-term settings like assisted living or skilled nursing. This can be needed at any age, and the types of long-term care you may need could change. So with ALS, right, there are some things that maybe you can do now and you need some help with, but then as time goes on, you may need more care or more assistance. And these, activities of daily living, your ability to do them can change. So it may be needed at any age. And, unfortunately, Medicare and most health insurance plans don't pay for long-term care. So planning for long-term care costs is something that's pretty important because it's largely an uninsured healthcare cost for most people. So planning for this ahead of time is a very good idea. It can help with effective retirement planning and something just to consider because it's probably not already included in your current insurance. So Medicare will cover up to 100 days of skilled nursing care provided in a Medicare certified nursing facility. So this is following an inpatient hospitalization of at least 3 midnights, which is kind of an odd way to explain that. But if you were inpatient for at least 3 midnights, 3 nights, and you go from there to a Medicare certified nursing facility, Medicare will cover up to 100 days of that. It'll pay the full cost of the first 20. There is a coinsurance payment for days 21 through 100. But if you have a Medicare supplemental insurance policy, that may cover it. And it provides home care to those needing intermittent skilled care. So it's usually also only post-hospitalization. Long-term, part-time skilled home care services are covered, but it does not include custodial care. So, which is the type of long-term care most individuals impaired by dementia specifically require, as well as some other illnesses. But this kind of custodial care, we talk about it with dementia specifically because it's care where you need somebody with you all the time, or you need to be in a secure facility where you are not a danger to yourself or others, or leaving and going somewhere else. So generally, we see that with dementia. Long-term care insurance is an option. So that's the only health insurance that pays for custodial long-term care, either at home or in a formal care center. So this type of like very intensive care where someone's with you all the time at home if you need something, or you're in a formal care center that's specific to that type of care. So some things you may want to look for or think about with long-term care. There are some long-term care insurances that also have life insurance. So that kind of is 2 policies in one. Maybe you want that, maybe you don't. If there are waivers for premiums after you've made a claim on long-term insurance or you're still paying, fixed premiums, or if that premium cost could change over time. Spousal portability, whether that is something that can be used for you and your spouse or just one of you. If there's a maximum daily benefit or maximum lifetime benefit of long-term care. If there are home care benefits, or if there are care manager benefits. So depending on what your wishes are for staying at home versus being in a facility, you would definitely want to look at the benefits for that specific thing to see if it's covered. And then Medicaid is also an option for longer term care. It's a federal and state program, and it's subject to federal law and federal monitoring. State law has the regulations and policies for Medicaid as well. So it's a federal program that's implemented on a state level. And the state will have a Medicaid agency. So for us, that's the Illinois Department of Healthcare and Family Services. And then the state comes up with eligibility determinations. So for us, through the Illinois Department of Human Services, they determine what you need to be eligible for Medicaid. So with Medicaid, this covers nursing homes. And then there are these other 3 programs that are considered waivered. So Illinois as a state has requested from the federal government to be able to have certain programs that are not in the federal Medicaid regulations be part of kind of their state Medicaid program. So nursing homes are covered under Medicaid federally, but Illinois has these three waivered programs. So supportive living facilities are also covered by Medicaid in Illinois. Community care programs for folks under or over 60 are also can be covered by Medicaid in Illinois. And then in-home services for folks under 60 can be covered in Illinois as well for Medicaid. Um, Medicaid can be pretty complicated to apply for. They have this 60-month look back period. So that's something, you definitely want to be thinking about your assets and looking at the eligibility because Medicaid will require 60 months worth of financial statements. So 5 years of financial statements and information about your finances. So if you do anticipate wanting to apply for Medicaid, maybe you're not planning to apply for it now, but you want to apply for it later. That would be something to start thinking about as soon as possible because that application can take some time to put together. And the better records you're keeping now, the easier it'll be to apply when it comes time for that. All right, so now we can go ahead and answer any questions. I do have a couple that I received ahead of time, so we can maybe get started with those. Okay, so the first one I have is, are there any legal planning tools that can help protect a spouse or caregiver from financial burden? I definitely think that what I talked about at the end, as far as long-term care insurance and Medicaid, those are things that you could be thinking about now to help a spouse or caregiver by, preparing looking at your assets, looking at Medicaid eligibility requirements if you plan to apply for Medicaid and sort of see what you need to be doing now to be prepared when that time comes. What should families know about transferring assets when planning for Medicaid eligibility? This is definitely something that is important to consider. So, and I would advise you to talk to an attorney about it more in detail. But part of why Medicaid looks 5 years back at your financials is because they're wanting to make sure that you aren't, just giving money to your family members to be eligible for Medicaid. And, if you are giving away large sums of money, they're probably going to ask questions about that. So you should not be planning to, take the contents of your bank account and give it to your child to be eligible for Medicaid. But what you can do is spend that money down. So your retirement accounts you could use to private pay at a nursing home until you're eligible for Medicaid. But with, if you are married, there and your spouse is living in the community, so in effect living at home, they are they're able to keep certain assets, and one of those assets is your home. So a house that's jointly owned by you and your spouse, they can keep that. That's not going to be counted by Medicaid. So I definitely would talk to an estate planning attorney if you have assets and you have a spouse that may be living at home when you're in a facility. That that's definitely something to talk about because it can be kind of complicated and is going to differ for every person.
Excuse me, can I chime in with one question that comes up very often regarding Medicaid? Oftentimes, you said the property would be protected, but what about other assets? Like sometimes people ask whether they should, like if it makes more sense to be divorced than married so they can have separate assets.
Mm-hmm. Yeah, so it's not permitted to just get divorced so that you have separate assets for Medicaid. So I would not recommend that. But there are things, so for example, like an annuity, you can take excess assets and put them into a Medicaid approved annuity so that it transforms these assets into a monthly income stream and allows you to preserve as many assets as possible while still being Medicaid eligible. So there are options for people who have assets. Um, but yeah, like things like cars that are jointly held, unfortunately, those are counted towards, the person applying for Medicaid. So as far as kind of asset management, there are, ways to preserve some of those things for your spouse. Let's see. What's one legal document you recommend every adult, regardless of health status, have in place? I think generally estate planning is something that everybody should be thinking about. What is going to happen with your assets? How are you going to manage those for kind of long-term care? I would say, though, that I think powers of attorney are something really important for people to think about now before maybe need them because, you don't know if you might have an emergency that leaves you incapacitated in a way that you didn't expect. And with a power of attorney, you've named somebody that you trust to kind of take over in case you haven't been able to lay out all your wishes or if you do have wishes and you want them to be implemented. All right. And then I have this other question. Can you explain how a healthcare POA, power of attorney, differs from a living will? Yes. So a living will, kind of what I was talking about with the 5 wishes and the physician's order. A living will sets out your wishes for what type of medical treatment you do or do not want to receive. A power of attorney can also lay those things out, but the power of attorney names a person who makes decisions for you. So a power of attorney, you're nominating an individual to make decisions for you when you can't, and you may outline some of those decisions that you want them to make. But a living will does not name a specific person. It just explains what types of treatment or like medical interventions you do or don't want.
I actually have 2 more questions, if you don't mind.
Yeah, for sure.
So you were talking about most of those legal documents. I imagine they are good across state lines, but there are some, I believe, that are state specific. Could you please elaborate a little bit on that? Because we share borders with other neighboring states.
Yeah, absolutely. You know, kind of, I guess, fortunately or unfortunately, many states have different regulations for all of these documents, right? So a trust that you make in Illinois is not necessarily going to be effective in Indiana. I will say as a whole, for powers of attorney for property and for healthcare, if you're trying to do something like 5 wishes, that's something that's effective over state lines. And, even for a power of attorney for healthcare, even if it's not a document that's legally binding in another state, just having it can kind of help direct physicians to see what your wishes are and to be able to make decisions in that way. Um, but generally, you would want to set up a trust or set up a will in the state where most of your property is located. So, as far as long-term financial planning, because there are different requirements from state to state, and there could run into a conflict. You would want to set up these documents wherever you have most of your property or where you're living, to do that because it can differ over state lines.
Yeah. I have a stupid question related to this. What if a person is a snowbird? So they go Arizona or Florida for the winter month, but their main residence is here and they get sick there and they have to have somebody. Will that work? Like
That's definitely not a stupid question. And it's something that, yeah, everyone would be thinking about. And I think for decisions, when you're talking about decisions being made for healthcare and for power of attorney, um, if your main residence is in Illinois, you've got an Illinois driver's license, and you make a power of attorney in Illinois nominating someone to make decisions for you in the event of you being incapacitated, that person can still make decisions for you when you're in Florida. Because it's an Illinois power of attorney. You are a resident of Illinois, so you are under the jurisdiction of Illinois courts. The reason I say it's a little bit different for financial things is because properties located in different states may be subject to different probate rules. Whereas when you're doing a power of attorney for healthcare, you can only be like a resident of one state at one time. So you would have your primary state of residence is where you would want to do this power of attorney.
Okay. I think we covered most of the questions that came through. Nothing came in now. So I think we're ready to wrap up.
Sounds great. Well, thank you so much for having me. I really enjoyed being able to talk to you.
Thank you so much for sharing your time, knowledge, and guidance. And thank you all for joining us tonight. We hope you're leaving with some helpful tools and ideas to make future planning a little clearer and less overwhelming. If you think you have any other questions that we did not cover today, please reach out. We're always here to help. You will receive an email with the recording once it's ready, so you can revisit the information or share it with someone who might benefit. On behalf of ALS United Greater Chicago, thank you for being part of tonight's program. We look forward to seeing you all our next Living Well with ALS educational program. Just a quick note that we're hosting in-person. Our next event is an in-person event that will be our 12th annual educational symposium and the Vendors Expo. It will be on the 29th of October on a Wednesday. That event is also free for individual living with ALS and a caregiver. Please register as soon as possible. The space is limited. It will be a luncheon, and we will have Dr. Richard Bedlack from Duke University as our keynote speaker. We love to see you there. So thank you again for attending tonight, and have a wonderful evening.